Hey guys, welcome back to the channel. Today we are going to talk about drug possession. Now, the concept of possession of drugs under common law in the United Kingdom generally requires two key elements: physical control and knowledge. Physical control means the individual must have the drugs either on their person or in the location they can access. Knowledge involves being aware of the drug's presence and recognizing that they are controlled substances. For instance, if someone carries a bag containing cannabis and is aware of its contents, they are considered to be in possession of the cannabis. However, if drugs are unknowingly planted on them, they lack the necessary intent, which aligns with the principle of mens rea, i.e. guilty mind, in criminal law. Under Singapore's Misuse of Drugs Act, also known as the MDA, the concept of possession is stricter, reflecting the country's zero-tolerance approach to drug offences. As with the UK law, possession requires physical control and knowledge. However, Singapore law also recognises constructive possession, where drugs found in places under the accused's control, such as their home or car, can be deemed in their possession. A distinctive feature of the Misuse of Drugs Act is the presumption of possession under Section 18(1), where individuals are presumed to possess drugs found on their person or property unless proven otherwise. Section 18, subsection 2, further presumes knowledge of the drug's nature unless the accused can demonstrate that they were unaware and could not reasonably have known about it. Therefore, the Misuse of Drugs Act shifts the burden of proof to the accused, significantly diverging from the innocent until proven guilty principle seen in other jurisdictions. There are both similarities and differences between the UK and Singapore's approach to drug possession. Both jurisdictions require some degree of control and knowledge for possession and recognize constructive possession. However, the laws differ significantly in their application. Singapore's presumption of possession and knowledge places a heavier burden on the accused, while UK law requires the prosecution to establish these elements beyond a reasonable doubt. This reflects a broader difference in approach, with Singapore adopting a stringent stance to deter drug crimes, whereas the UK focuses more on individual intent and fairness in the judicial process. The penalties for drug possession under the Misuse of Drugs Act in Singapore are among the harshest globally. For example, possessing up to 30 grams of cannabis can result in up to 10 years of imprisonment, a fine of up to 20,000 or both. Similarly, possession of up to 25 grams of methamphetamine carries comparable penalties. For heroin, possessing more than 2 grams triggers the presumption of trafficking, with amounts exceeding 15 grams punishable by the death penalty. These severe penalties underscores Singapore's commitment to eradicating drug offences and protecting public health and safety. Singapore's strict approach reflects its prioritization of collective welfare and deterrence. While the presumptions under the MDA enhance enforcement capabilities, they also raise concerns about fairness and the potential for wrongful convictions. In contrast, the UK's emphasis on proving intent safeguards individual rights but can make securing convictions more challenging. Both systems embody the values of their respective societies, with Singapore focusing on societal safety and deterrence and the UK balancing enforcement with fairness. The contrasting approaches invite reflection on how best to address the global issue of drug possession while respecting the rights of individuals and protecting communities. That's all for today's discussion. Don't forget to like, share and subscribe, and I'll see you in the next video.